It's an honor for me to welcome our esteemed Chief Guest, Professor Dr. Vandana Arora from Department of Law, Punjab University, Chandigarh. Our worthy principal, Dr. Balraj Thapaji, to the event. I would also like to welcome my fellow colleagues and dear students and thank you all for gracing the occasion. Now, I will invite Principal Sir, Dr. Balraj
Ma'am, I think there is some connectivity issue.
We are.
Okay.
Hello, am I audible?
Good morning, sir. You are audible.
Yeah. Good morning, ladies and gentlemen. Esteemed Professor Dr. Vandana Arora, honorable members of staff and dear students. It's a matter of great pleasure and pride that a person of Professor Dr. Vandana Arora's stature and eminence is amidst us as a resource person. Her words of wisdom will be a source of inspiration and stimulation for all of us. We are deeply beholden to her for sparing her valuable time to be with us on this occasion. Dr. Vandana Arora is a product of Punjab University. She obtained her LLM degree in 1998 from Punjab University and completed her PhD from Punjab University in 2009 on the topic Justice Delivery in India, a critique with specific reference to Supreme Court of India. She has supervised more than 20 LLM dissertations, 3 PhD theses, and is supervising 6 PhD scholars. She has published more than 23 papers in national and international journals. She is content writer for set of modules in E-Pathshala project of UGC. She has a vast administrative experience. She is the founder warden of International Hostel of Punjab University. She is on the panel of UPSC, evaluators and examiner of SCS judicial exams. The topic of today's webinar is quite interesting. That is the role of Supreme Court in the expansion and protection of fundamental rights of the citizen. Every government has got 3 organs, that is legislature, executive, and judiciary. Legislature legislates the law, executive executes the law, and judiciary decides the law. Judiciary is considered to be the guardian of the rights. Fundamental rights are the cornerstone and foundation stone of any democracy. Lasky has rightly said that every state is known by the system of rights it maintains. Indian Constitution gives the fundamental rights to the citizens of India for the development of their personality. For the protection of the rights, the judiciary comes. The lamp of justice must be kept burning. Otherwise, you can very well imagine how great will be the darkness. Supreme Court is the guardian and custodian of these fundamental rights. These rights are justiciable, and in case of violation, individuals or institutions can directly approach the Supreme Court. But there has been some controversy regarding the fundamental rights. In 1967, in Golaknath versus Punjab, Supreme Court said that Parliament does not have the right to amend the fundamental rights given in the Part 3 of the Constitution. In 1971, 24th Amendment was done and Parliament acquired the right to amend the fundamental rights. In 1973, in Keshavanand Bharati and Kerala state, Supreme Court reversed its decision and said that government has power to amend the fundamental rights. In 1976, by 42nd Amendment, the government said that no amendment will be challengeable in the court. But in 1980, in Minerva Mills and Union of India case, it was decided that Parliament can amend any part of the Constitution, but with the condition that the basic structure of the Constitution should not be changed. Now I'll not stand between you and Dr. Vandana Arora. Thank you. Thanks a lot.
Thank you very much, sir, for introducing me, as also introducing the theme also. And in fact, I would say that it will make my work more easier, because the backdrop which I required, you have already given. Thank you so much, sir. Respected principal, sir, organizing team of the webinar, the staff of the college, and my dear students, a very good morning to all of you. First of all, I would like to thank Principal Sir and organizing team of today's webinar for giving me a wonderful opportunity to interact and talk with the students of Department of Political Science of your esteemed college, SD College, Chandigarh. And I would also like to appreciate and congratulate also the Department of Political Science, especially Dr. Seema and her team, for organizing a webinar on the expert advice of the principal, respected principal, sir, and the topic which is highly relevant in the present times, that is the role of Supreme Court in the expansion and protection of fundamental rights of its citizens. Now, moving on to the theme of the webinar, dear all, first of all, I will just like to give you a backdrop of the today's theme, though sir has already given you the backdrop about the fundamental rights and the Constitution of India. But here I would like to just give you a backdrop of part 3 of the Constitution, so that everyone will be able to comprehend that what I am going to talk about in today's webinar. And that will just be a part 3 of our Constitution. I always say it as our Constitution. Our Constitution, because as every student of political science has read the preamble to the Constitution, which starts that with we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and that we give to ourselves this Constitution. So it is we the people of India who has given this Constitution to ourselves. So this is our Constitution. Therefore, I always say part 3 of our Constitution. Now, Indian Constitution is a written document that lays down a composition of various organs of the government and relationship among them. And it also sets the limits on the power of the government and ensures that democratic government, or the system in which we all persons lives, enjoy certain rights. We all enjoy certain rights. And part 3 of the Constitution of India lists those fundamental rights. Not only it lists the rights, it has also put certain restrictions on it. So during the last 70 years, the scope of these fundamental rights, which was guaranteed by our Constitution in part 3 of the Constitution, has changed. Scope has changed. It has widened. It has expanded. And in this way, we can say that how the right which is contained in them, which were implicit in them, were widened. It is only through the interpretation which the Supreme Court has given to these rights. Now, these rights, which we call as a fundamental rights, they are also known as basic rights. We call them as human rights as well. And the idea of guaranteeing these basic rights is to ensure that individuals have a minimum guaranteed freedom and protects a person against oppression and arbitrariness and injustice in a society, and also against excesses of the government. Now, the framers of US Constitution, as far as back in the year 1787, they were the first to give concrete shape to the concept of these human rights by putting them into the Constitution and making them justiciable and enforceable in the court of law. Justiciability and enforceability is the most important if government or if Constitution is giving us any right, and if that is not enforceable, we will not call it as a right at all. So they are being made justiciable and enforceable through a court of law. And so far as India is concerned, during our freedom struggle, the leaders has realized the importance of these rights and demanded from the British rulers that they should give this these basic rights to the Indian people as well. And this demand relates back, the first demand regarding their inclusion relates back to the year 1895 in what we call it as a Swaraj Bill, which was inspired by our well-known freedom struggle movement leader, that is Lokmanya Bal Gangadhar Tilak. After this particular thing, every meeting of the committee, Indian National Congress, it founds its inclusion, the inclusion of these rights, the demand for inclusion of these rights in those meetings. For instance, in the year 1928, Motilal Nehru Committee made a demand for the Bill of Rights. Then in the year 1931, in its Karachi session, Indian National Congress reiterated its resolve that written guarantee of fundamental rights was essential to any future constitutional setup in India. Again, the subject of fundamental right figured prominently in the discussion of Sapru Committee, which was set up from 1945 to 47, where Sapru Committee formally and categorically said that in a peculiar circumstances of India, fundamental rights were necessary, not only as an assurance and guarantee to minorities, but also for prescribing a standard of conduct for other organs of the government, that is legislature, be it executive, be it judiciary. And finally, on 26th January 1950, when India became sovereign democratic republic, part 3 of the Constitution was granted these basic rights, or the human rights as the Universal Declaration of Human Rights call it, to its citizen in the form of fundamental rights. These rights are not only guaranteed in writing alone, but the Constitution in this particular part of the Constitution has also laid down the provision for enforcing, in case of infringement, for enforcing them through the judiciary by way of writ petitions, and under Article 32 and Article 226 of the Constitution of India. Moreover, the fundamental right imposes a restriction on the executive and the legislative actions, as these rights cannot be taken away by ordinary law, nor they can be infringed by any organ of the government when they work or during the course of their functioning. Now, moving on to the theme of the topic today, that is what role Supreme Court has played when these fundamental rights have already been granted. So what role the Supreme Court has played in interpreting them and which leads to the expansion of these rights or protection of these rights. I would say that the Supreme Court has played a significant role through its remarkable judgments in the protection and expansion of fundamental rights of its citizens. And it will not be wrong to say that while doing so, it has acted as a watchdog. It has acted as a watchdog of these rights, watchdog of the Constitution. So when we talk of watchdog, even the Constitution has assigned this role or underlined this role of being a watchdog to the Supreme Court through Article 32, Clause 1 of the Constitution. Now, the Supreme Court in the case of Dayal Singh versus UP has commented on its role as a guardian and protector of fundamental rights of its citizen by observing that the fundamental rights are intended not only to protect the individual's right, but they are based on high public policy. Liberty of individuals and protection of its fundamental rights are very essence of democratic way of life adopted by the constitutions. And it is the privilege and duty of this court to uphold those rights. This court would naturally refuse to circumscribe them or to curtail them except as provided by the constitution itself. Again, in the year 1950, in the case of Ramesh Thapar versus State of Madras, Supreme Court has emphasized that the court is thus constituted as the protector and the guarantor of fundamental rights, and it cannot refuse to entertain applications seeking protection against the infringement of these rights. So, Supreme Court, though Article 32 itself is giving it is giving a duty and obligation upon the Supreme Court to take care of these rights of the citizens. Through its number of judgments, Supreme Court has accepted its duties and it has gone a long way to just protect and expand these fundamental rights of the citizens. Now, in the year, while when number of cases have been coming up before the Supreme Court, we see that number of times a ticklish sort of questions also came up before the Supreme Court, and while interpreting it, it has to apply its mind to the extent that it has to go through even refer back to the Constituent Assembly debates to know what was the intention of legislature while answering those questions, while making the provisions of fundamental rights in the Constitution. For instance, in the year 1955 and again in the year 1959, the question which came before the Supreme Court was, can a person waive any of his fundamental right? This was the question. Now, these two questions, this particular question were raised in two petitions. One was Behram versus State of Bombay, AIR 1955 Supreme Court, and other was Vishesharnath versus Income Tax Commissioner, that was in the year 1959. And the Supreme Court, what the Supreme Court has held, क्या कि fundamental जो rights हैं वो waive कर सकता है citizen? He can say that I don't want to have my rights, or he enter into for instance, he enters into a contract with the government whereby he has waived his right. To this particular thing, the Supreme Court has held, none of the fundamental rights can be waived by any person. The fundamental rights are mandatory on the state, and no citizen can, by his act or conduct, relieves the state of its. ये state की solemn obligation है. So nobody can relieve the states of its solemn obligation imposed upon it. A large majority of, because why they say that they cannot be waived? Because it says a large majority of people in India are educationally backward, they are economically poor, and politically not yet conscious of their rights. अगर individually भी देखें, उन्हें collectively भी देखें, individually or collectively, they cannot be pitted against the government, and therefore it is the duty of the judiciary. तो जब government के against rights हैं, तो it is the duty of the judiciary to protect their right against themselves also. अगर वो waive करते हैं तो उसको भी protect करो. Thus, settled law is that individual cannot waive any of its fundamental right. Or in other words, state cannot arrogate to itself the right to commit a breach of fundamental right of any citizen by resorting to the principle of waiver or estoppel or other similar principle. However, I want to add here that in USA, fundamental rights can be waived by the citizen. So, यहाँ पर Supreme Court has tried to make a difference between what is happening in the other countries and what is happening in India. For instance, I have given you an example. In USA, fundamental rights can be waived. It is because people out there are very conscious of their right, and if they are waiving it, they know what they are doing. So here the Supreme Court has emphasized this fact. I would like to just tell you once again that why the court says that it is an obligation of the state, and even the citizen, when the citizen will try to waive their right, it is the duty, bounden duty of the court कि नहीं आप violate नहीं करेंगे, and to protect the right against themselves also. अब लोगों के against भी लोग भी अगर कह रहे हैं हम waive करते हैं, तब भी उन्हें वेव ना करना दिया जाए. This is because a large majority of people in India are educationally backward, economically poor, and politically they are not conscious of their right. जब उन्हें rights का इतना पता ही नहीं है, तो it will be very easy for the state to make a fool of them and can say that you have entered into a contract, or you earlier said that you will waive your right, and this is why we have waived your right. So that is why though in USA this can be waived, but not in India. Then another crucial question which came before the Supreme Court was that whether fundamental rights can be amended under Article 360 of the 68 of the Constitution or not. This has also been referred to by the principal sir also while introducing the theme, and this is really very, very important, because if fundamental rights can be amended, because this is a part which gives certain rights to the individuals. So these are which are fundamental to his existence in some cases. So whether these fundamental rights can be amended by the Constitution, or in other words, that by way of amendment they can be taken away. So this is the crucial question which came up before the Supreme Court, and the Supreme Court, through its various judgments, starting from Shankari Prasad case to Golaknath case to Sajjan Singh's case to Keshwananda Bharti's case to Minerva Mill case, has reached the conclusion and held that Parliament is competent to amend fundamental rights under Article 368 of the Constitution, just as any other part of the Constitution, but subject to the doctrine that basic structure of the Constitution, जो Constitution के basic values हैं, आप उनको amend नहीं करेंगे. Within that premises, within that arena, you can amend, but जो basic structure है वो as it is intact रहेगा. So just as any other part of the Constitution, Parliament has a power to amend Constitution, fundamental rights also, or Part 3 of the Constitution also, but subject to the doctrine that the basic structure of the Constitution cannot be amended. But who will decide whether they are violating the basic structure of the doctrine of basic structure or not? So it is the judiciary who needs to intervene and to decide while making an amendment whether the Parliament is going it's remaining within the or preserving the basic structure of the Constitution or not. So so the majority ruled that while Parliament can amend fundamental right under Article 368, such a power is not absolute and is subject to the judicial review. क्या देखने के लिए? To see whether the amendment destroys the basic structure or the basic feature of the Constitution. ये देखने के लिए judiciary still has a power. Leaving it to the court, सारा कुछ कोर्ट पे लीव करता है, and leaving it to the court to decide which fundamental rights will be regarded as a basic feature, because in one of the cases the court has even gone to the extent of dividing the rights into two parts which are very essential, or which are the basic features, or which cannot be treated as a basic feature of the Constitution, looking at it to the constitutional values and fundamental principles. So in that case, the law says, the court says, okay, we will decide when you make an amendment in fundamental right, it will be the court who is to decide whether while making an amendment, the government has, whether the Parliament has violated the basic structure theory or not. अगर वो basic feature जो उसका basic feature है जिस पे whole of the Constitution stands, वो violate नहीं होता, only then fundamental rights can be amended, otherwise not. Now, moving on to all the fundamental rights which are laid down in the Constitution, let us first of all take up one of the most important and the significant right of all other rights which is provided in the Constitution, and which is Article 21 of the Constitution. Article 21 of the Constitution, which guarantees right to life and personal liberty to all the citizens and non-citizen. So it is no person. It starts with the word no person can be deprived of life or personal liberty except according to procedure established by law. So the right to life and personal liberty, which is given by the Constitution, is available not only to the citizens of India, because it directly relates to life or liberty, personal liberty. So it is also available to the non-citizens. So it is available to both of them. So it was in fact in Menaka Gandhi versus Union of India way back in the year 1978. Supreme Court has, we say that, ushered in a revolution in judicial thinking and given a new and fresh lease of life to Article 21 and extended both the procedural as well as substantive protection to right to life and personal liberty. Now, after this case, Supreme Court has got a chance to interpret the right in number of cases, and even through public interest litigation, when the Supreme Court, even in number of cases, has treated a postcard sent to it as a petition and goes on and on to bring about a social transformation. So while interpreting Article 21, the court has gone to the extent that now we can say that the Supreme Court has brought about a transformation, social transformation. Here I think I should mention that we will not be able to just go through all the important case laws, and the idea should be just to put forward the role of the Supreme Court. So I should just be discussing those rights, or the fundamental rights, how they have interpreted it, or how they have expanded it, or how they have protected the fundamental rights of the citizen, by just under some headings only, because it will not be possible to go in detail with respect to all the cases. So I would here be emphasizing on the gist. जो जिस्ट होगा, जो लॉ आपको पुट फॉरवर्ड लॉ है, जो एग्जिस्टिंग लॉ है, वो आपको अंडरस्टैंड करना ज्यादा जरूरी है. तो आई वुड बी एम्फेसाइजिंग ओनली अपॉन द लॉ इंस्टेड ऑफ अननेसेसरी, एक्सेप्ट इन वेरी वेरी इंपॉर्टेंट केसेस व्हेन जो लैंडमार्क जजमेंट्स हैं जिनका नाम यू मस्ट नो. तो आई वुड जस्ट बी टेलिंग यू दिस इज द लॉ नाउ in the present scenario. So that is why I say that selectively only I will be able to choose the area, because as per the time constraint we have. Fine. So far as so we can say that fundamental right, जो Article 21 का I want to start with, because it has been interpreted to include in it number of things. अब तो अगर आप right to life और personal liberty एक लाइन नहीं है, it in fact affects every, अगर आप उसकी interpretation देखेंगे सुप्रीम कोर्ट की, every facet of human life is being interpreted कि किस तरह आपने life को चलाना है, क्या arrested person के right होने चाहिए, कौन से right environment से related हैं, कौन से right livelihood से related है. It includes it has touched, I mean, every aspect of human life. And it is very interesting to see how the Supreme Court, looking into the, it is not copying it from anywhere, it is seeing the social condition which is there and interpreting it by that way. So the Supreme Court has played, I again say, a significant role so far as Article 21 is concerned in laying down new liberal norms for every aspect. जैसे हम criminal justice system से start करते हैं, so you can say it has liberally interpreted. Supreme Court ने इसको इतने liberal norms के हिसाब से interpret किया है. You can say it has tendency, जो judgments आ रही हैं उनसे तो आप देखेंगे, it tends to humanize and liberalize the administration of criminal justice. This is the first right. You can say Supreme Court says that right to life includes right to life and personal liberty. It includes right to speedy trial. Right to speedy trial, क्योंकि अब हम criminal justice system की बात करें, we all know justice delayed is justice denied. Therefore, the Supreme Court has time and again emphasized upon a speedy trial, right to speedy trial in criminal cases. Though it is not a specific fundamental right, the court has held that it is implicit in the broad sweep and the contents of Article 21. जो right to speedy trial है, तो वो implicit ही है Article 21 में, contents of Article 21. And a fair trial implies a speedy trial. अगर आप fair trial की बात करते हैं, because there cannot be a whole, you see, so far as criminal law is concerned, I must just want to clarify here that we have two basic things in criminal law. One is IPC, that is a substantive law. Another is a criminal procedure code, which is a procedural law. And जो procedural law है, procedure के ऊपर the Supreme Court has held कि जब हम procedure follow कर रहे हैं, तो there should be a speedy trial. Procedure should not be hurdle in deciding the case. And if you see the provisions relating to the fair trial, they are spread over whole of the criminal procedure code. अगर fair trial नहीं है, तो it is no trial at all. Or a fair trial, court says in this case, in number of cases the court says a fair trial includes or implies a speedy trial. अगर वो fair trial है, तो वो speedy trial होना बहुत जरूरी है. For instance, in the case of Hussain Ara Khatun versus State of Bihar way back in the year 1979, Supreme Court, commenting upon the conditions of under trial who were languishing in jail for years together, and in some cases they were in the jail for the time which if they could have been sentenced for the offense they have committed, that has already been gone. तो इतने ज़्यादा time period के लिए कि उनका sentence जो उन्हें मिलना था उससे भी ज़्यादा. There is a case where the person remained in a prison for about 77 years. So, not 77 years, like by the time he was 77 years, almost about more than 40 years, when he came out of the jail, he has already spent more than 40 years in the jail, and he was 77 by that time. So whole of his life was spent in the jail, and he remained under trial. Fine. So looking on to all these nonsense which was going on in that time, Supreme Court, commenting upon the conditions of under trial who were languishing in jail for years together, and in some cases in the jails for the period longer than they could have been sentenced to if properly tried, the court has held. Now see what the court has held. It is a crying shame upon our adjudicatory system which keeps men in a jails for years without trial. Under trial का मतलब उसका trial ही नहीं हुआ है. ठीक है, not to take, it is only so long as there is a one cardinal principle of criminal justice system, that person is presumed to be innocent till he is proved guilty beyond reasonable doubt. जब तक उसका guilt prove नहीं होता है, तब तक वो innocent है. वो उसको हम कहेंगे he is accused of committing an offense, he is not guilty. तो इस केस में जो अंडर ट्रायल्स हैं, तो वहां अंडर ट्रायल का मतलब उनका या तो ट्रायल स्टार्ट हुआ है या वो अभी ट्रायल ही स्टार्ट नहीं हुआ है. सो द कोर्ट सेज कि इट्स such a situation, the court says कि we should treat it as like it is a crying shame. कोर्ट कहता है it is a crying shame upon our adjudicatory system which keeps men in jail for years without trial. So this is it recognizes the right of the citizens to a speedy trial in criminal justice system. Then another innovative step in the scheme of criminal administration was introduced by the court has been to insist upon free legal aid. It is to Sorry for the interruption. So another innovative step in the scheme of criminal administration was introduced by the court, has been to insist upon free legal aid. एक जो free legal aid का जो concept है, for which in almost all the educational institutions we do have legal aid clinics also, जहाँ पर free legal aid is being provided, and इसका जो statutory provision भी है, ये fundamental right भी recognize हुआ है by the Supreme Court. और इसका so many cases have come up before the Supreme Court, and Supreme Court ultimately through its various judgment has held that right to free legal aid is a fundamental right of the accused person. Not only the right कि ये सिर्फ right paper में दिखाने के लिए नहीं है. It is not only, it should not only be left on the papers. Right to free legal aid, any person who is a poor, who cannot afford a lawyer, he has a right, because, and this is one of the essential ingredients of fair trial also, because if you give an opportunity to one of the parties to be represented by the legal practitioner of his own choice, another person, because of his poor economic conditions, he is not able to engage a lawyer, that means he himself is standing, and on the other hand, the lawyer is standing. So it is not going to do justice in that case. So that is from there the idea of free legal aid comes, and free legal aid clinics have been established, and Supreme Court has said that it should be there in all the educational institutions, so that legal aid can be provided to the person who cannot afford a lawyer. So then the court says, okay, free legal aid we recognize. Then from where it starts? It says the right to free legal aid starts. कब उसको लॉयर की, when he should be provided a lawyer, और ये legal aid जो दी जाए, it starts from the very first day. It is not जब trial start होगा तभी से free legal aid दी जाएगी. It starts from the time when the person for the first time is produced before a magistrate. जब पहली बार वो magistrate के आगे आएगा, then he will be then it is okay in one case. It starts from the time when he is for the first time produced before the magistrate, and it goes on till the time the trial decides the case. The whole of the trial eventually ends up in acquittal, or in the acquittal, or in proving or conviction. Then again the Supreme Court says that it is not enough. Then it says how to ensure that the person is getting a free legal aid. So because it is not expected that in our country the person will come to know कि उसका legal right है. So it says it impose in another judgment, it impose a duty upon the magistrate. उसने duty ही लगा दी magistrate के ऊपर कि it is your duty to ensure कि अगर if anybody comes before you for a trial and he is not represented, जब भी आपके सामने produce होता है and he is not represented by the lawyer, it is the bounden duty of the court to ask him the question कि where is your lawyer कहाँ है आपका, and if he says that I cannot afford a lawyer, then it is his duty to tell the person that you can be provided a lawyer free of cost. You have a fundamental right to free legal aid. Then अगर वो right है तो then then the court gone a step further and saying कि unless denied, जब तक वो person himself deny करे कि मेरे को ये मुझे नहीं चाहिए free legal aid, I will myself represent my case, until that is done, the right to free legal aid, to provide a free legal aid, is the bounded duty of the court where the person is being produced. So that means, see, the interpretation starting from recognizing the right, then moving on to ensure that that right will in fact be effective. The court has gone a long journey in reaching to the conclusion, and now the present position is that unless denied, the right to free legal aid must be provided to a person who is an indigent accused. Fine. Then moving on to, we can always say that Supreme Court in number of cases, Supreme Court was really anguished with the way the police authorities are acting arbitrarily, or in deciding or keeping the persons in jail, inhuman treatment which they have been giving to the persons in the jail. So in number of cases, Supreme Court has passed strictures against the police torture and their brutality on the prisoners, handcuffing of the prisoners, third degree treatment which they give to the prisoners. And in D.K. Basu versus State of Bengal, it is a very landmark case, along with the Joginder Kumar's case and D.K. Basu case versus State of West Bengal. They are very important. They are authorities on the rights which the Supreme Court has given to the arrested person. Once they are arrested, that what guidelines, detailed guidelines have been laid down by the Supreme Court to be followed by the authorities, so that they should not act arbitrarily, and the right to life and personal liberty of the person should be in fact remain intact, and really they should feel, the people in the country really feel that their right to life and personal liberty is protected. Number of guidelines have been laid down to be followed by the authorities in case they make an arrest of the person. Now these guidelines which were laid down by the Supreme Court has become a part of CRPC provisions in criminal procedure code. अब बिल्कुल डिटेल में ये गाइडलाइंस लिख दी गई हैं. So, D.K. Basu versus State of West Bengal and Joginder Singh's case, court issued several directions to be followed in case of arrest के बाद और detention कैसे करनी है till the legal provisions are made in this behalf. And now I am telling you that these provisions have already been incorporated in CRPC. Not only in case of general public, see how the court is to work and where the court is to interfere. Not only in the case of general public with regard to the guidelines which it has laid down for the arrest and the detention of a common man, the court needed to intervene in a case against the police high-handedness and insensitivity and arbitrariness when they dragged a judicial officer to the police station. So there the court intervened in what is popularly known as Delhi Judicial Services case, Delhi Judicial Services versus State of Gujarat. Us case mein, the Supreme Court has laid down a detailed guidelines to be followed in cases where there is a need to arrest a judicial officer. So a complete guideline have been laid down by the Supreme Court in that case, and in no case a judicial officer can be arrested by the police, because in that case they have dragged the person who was a judicial officer to the police station, and the court says it has affected the dignity of a whole of the court, and the court says that you need to be sensitive enough, and the police need to follow a specific guidelines before arresting a judicial officer. Jaise ki if they need to arrest a person, they must inform the high court under whose jurisdiction that person works, or even they need to take a permission from the session judge and inform the session judge that such and such person is they need to arrest that person. And to be more simple, then they must the police jo judicial officer hai, he must be given a right, he must be given an opportunity to consult his lawyer ya jo uska colleague hai before taking him to the custody, or so these guidelines have been laid down in the Delhi Judicial Services case, or usko legal aid usko bhi provide. If he wants that he should consult he wants to contact his lawyer, he be allowed to contact his lawyer. His family members and friends must, जो भी वो फ्रेंड्स को इन्फॉर्म कर सकता है वो करना चाहता है, they must be informed that person has been arrested on such and such charges and he has been taken, he needs to be taken. So permission लेके, और अगर उस परमिशन के लिए टाइम नहीं है तो एटलीस्ट दे बी इन्फॉर्म्ड कि this thing they are doing, the police must inform the court that they are doing this to this judicial officer. So to provide a protection to these judicial officer from the high-handedness and the arbitrariness of the police, these guidelines have been laid down to be followed by the police authorities while making an arrest of a subordinate judicial officer. Then further the court in when it comes to, so this was about the criminal justice system. Then even on livelihood, when we talk of a livelihood, the court has in Lega Telly's case, in number of cases the court has held that right to life includes the right to livelihood. कि अगर livelihood ही नहीं है तो person कैसे how do you expect that person will survive? तो इसमें Supreme Court has held that easiest ways to deprive the right to life to a person is to deprive of him of his livelihood. So the court has said that right to life includes right to livelihood. Then you all must be aware of the role the Supreme Court has played in the protection of environment. So uske liye I always say is that Supreme Court has made a signal contribution by using Article 21 towards improvement of the environment. Okay? And it would not be wrong to say that whole of this environmental jurisprudence is an outcome of the active role which the judiciary has played in protection of the environment, because it has laid down in every case, whenever a case comes before the Supreme Court and it relates to the protection of environment in one way or another, it has performed its duty to the next level in saving the safeguarding the environment and the ecology. and it has laid down number of principles also through its judgment, which needs to be applied to see that at all the cost the environment needs to be, our environment needs to be protected. And in like the polluter pays principle कि जो भी pollute करेगा वही उसकी that needs to the remedy is that अगर कोई pollute करता है तो उसको ही उसका payment करना पड़ेगा उसको rehabilitate करने के लिए. और then there is a public trust doctrine जो है कि जो भी है ये सब you have whatever environment or ecology we have, we are keeping it as a trust. और तो ये हम next generation के लिए और sustainable environmental jurisprudence जो Supreme Court ने कहा है. So this is all what the Supreme Court has always been active in preserving the environment, and it has led to development of a new subject, that is environmental jurisprudence, and it is all the contribution of judiciary, I must say. Then another area where the Supreme Court has always been active, and that is Supreme Court has held that right to life includes a right to education also. So education ke upar bhi Supreme Court has been emphasizing that it is the duty of the state government to provide education, or through its various judgment that right to life includes right to education, and ultimately it has led the parliament to introduce a new fundamental right in the constitution by way of article 21A. Yeah, article right to education fundamental right ban gaya hai under article 21A of the constitution. Then there are other areas also, for instance when it comes to bonded labor, abolition of bonded labor, forced labor, or the child labor, Supreme Court has been very active, has remained very active for that also. But it is only in the year 1982, that is for the first time, that is 50 से लेके 82 में it was first time that Supreme Court had given an expansive, it has expanded significance to the term forced labor. कि forced labor क्या है under article 23 of the constitution, and that too in Asiad case. जब एशियन गेम्स हुई थी तो वहाँ पे एक एशियाड सिटी बनी थी, तो वहाँ पर दिल्ली के पास, तो वहाँ पे जो एशियाड केस है, then court strikes at the forced labor, this word forced labor pay, and insisted that this article is intended to abolish every form of forced labor, even if it has its origin in contract. चाहे it is even if the person has contracted कि मैं बिना I will work for this much amount only, or even if he has entered into a contract for a forced labor, even then the Supreme Court says no, it is a forced labor and it has to be abolished. And further the Supreme Court has held that the payment, even the payment of wages जो उनका बनता है उससे कम देना, payment of wages less than the minimum wages also amount to forced labor. So Supreme Court has tried to abolish forced labor or bonded labor, and even in the area of to eradicate this child labor, the Supreme Court has done a significant and very important work towards this. Then other thing which we can see or seek is that so we can also look into the role the Supreme Court has played in ensuring a peaceful environment to work peacefully and with the dignity, and that is in cases of sexual harassment of a woman at workplace. There the suppose in the case of Vishakha versus State of Rajasthan was the case in which the Supreme Court has laid down detailed guidelines to be followed by all the employers कि आपको ये guidelines follow करनी है wherever the women are working, so that, and the Supreme Court has held that the sexual harassment of a woman at a workplace amounts to violation of rights of gender equality and right to life and personal liberty under Article 14, 15 and 21 of the Constitution. और वहाँ पर Supreme Court ने has laid down in this Vishakha's case detailed guidelines were laid down and which are required to be followed, and ultimately after about so many years the guideline remained there, but they become an act now, that is prevention of sexual harassment of women at workplace. एक act पूरा बन गया, and under this what will amount to sexual harassment has been defined in detail, or what steps the authorities needs to ensure for the prevention also of prevention as well as prohibition of sexual harassment of a woman at workplace. उसमें detail लिखा गया है, and वहाँ पर एक there is one provision whereby a committee must be constituted अगर कोई ऐसी complaint है that has to be redressed, that too in a time bound manner. And not only this, detailed provision has also been laid down with regard to the thing that is to spread awareness among or sensitize the employees with regard to the provisions of this act, because if the employees are aware of, and it is the duty of the employer to conduct the workshops also, which relates to make sensitize the working force regarding the rights which the women have against their sexual harassment, that nobody can harass them. Because it should provide them an environment, a peaceful and environment जो उन्हें आराम से जहाँ पे वो काम कर सकें, that is to be provided. So it was in Visakhapatnam versus state of Rajasthan where judicial legislation was done. Fine. So these are some of the cases, and very recently I think I should also mention about the Supreme Court judgment wherein it has held that affordable medical treatment is a fundamental right. Ki affordable medical treatment is a fundamental right. In this case, Supreme Court has taken up the issue of healthcare during the times of pandemic. Suo moto उसने action लिया है of its own and looked at the instances where the bodies of coronavirus casualties were not held with dignity. तो वहाँ पे pandemic जो है COVID-19 का, उसमें Supreme Court has suo moto taken action and held that right to health is a fundamental right under Article 21 of the Constitution, and right to health includes right of affordable treatment. Therefore, court says it is the duty upon the state to make a provision, ऐसे provision बनाओ that is of a affordable treatment. और उसके लिए suggest क्या किया है Supreme Court ने? Suggesting on this, Supreme Court has held either more and more provisions are to be made by the state government or the local government or local administration, or there shall be a cap on the fees which is being charged by the private hospitals to deal with the COVID cases, and which can be done in the exercise of the power under Disaster Management Act जो है उसके अंडर ये power देती है. So judges has also asked the government to step up fire safety measures in the hospitals and issue the guidelines for giving relief to the doctors engaged in a COVID duties, and ensures that all जो meeting या political meeting है या any type of meeting which is being held must follow the COVID guidelines जो उसके during issue हुई है MHRD की जो guidelines हैं. So I think through these judgments and through these the Supreme Court, you will also agree with me that Supreme Court has done a wonderful job. It has really done its duty, and as a guardian or as a protector of fundamental right, and wherever required it has expanded, widened the scope of a particular article and tried to include all those things which are not a part of fundamental right on the face of it. अगर prima facie वो नहीं दिखते हैं, but the court has, by expanding it, it has said that it is implicit. These things are implicit in this particular article, or this article will have no value if these things are not granted to it. Like right to life includes right to livelihood, like right to life includes clean water, clean drinking water, clean environment, and right to life not only includes a right to live just as an animal existence, it includes a proper life. So all these things have been, right to life includes right to health, and the treatment which the latest court is saying in the COVID situation also, where it has suo moto entered. So in every aspect of life, I would like to say the Supreme Court has tried its level best to come up to the expectation of the people. And there was one movie also, that is Jolly LLB, where in the last stage of the movie the court says, the judge said that कि कुछ भी हो जाए लास्ट में कोर्ट पे ही लोग आते हैं, and always say they have a trust, people really trust the judiciary like anything. So at the end of the day, it is the judiciary which is which has played an important and wonderful role in protecting and promoting the rights of the citizen. But here I just want to add two more points. कि अगर हम इतने राइट्स के बारे में बात कर रहे हैं तो ये सारा चीज़ें इन्फोर्स कैसे हो रही हैं. फॉर इट्स एनफोर्समेंट you will all agree with me that the right without remedy is no right at all, and unless therefore if these rights are violated, person can एंड अगर ये राइट इन्फोर्सेबल ना हो, अगर रेमेडी नहीं है इस राइट की, तो ये यूजलेस है. सो देयरफॉर इफ दीज राइट्स आर वायलेटेड, पर्सन्स कैन, what can person do? They can approach the highest court of the land, that is Supreme Court directly, or even the High Court. वैसे otherwise the general rule क्या है law में, as far the procedure is concerned, general law is, or general rule is, whenever there is any offense or there is a civil wrong or there is any violation of right or infringement of right, aggrieved party has to approach the trial court first. जो नीचे वाली कोर्ट है उसको पहले अप्रोच करना पड़ेगा, जिसको हम लोअर कोर्ट कहते हैं, ट्रायल कोर्ट को पहले अप्रोच करना पड़ेगा. एंड इट इज ओनली through appeal that they can go to such an higher court, that is High Court or the Supreme Court. But in the with respect to the violation of fundamental rights, the Constitution itself provides that aggrieved party can come to the Supreme Court directly under Article 32 of the Constitution, or they can directly go to the High Court under Article 226 of the Constitution. And I must mention here that Dr. B.R. Ambedkar in the Constituent Assembly debate remarked that if I was asked to name any particular article in this Constitution as the most important article without which the Constitution will be nullity, कि उसके बिना Constitution null and void हो जाए, I could not refer to any other article except Article 32 and of the Constitution, and it is the very soul of the Constitution, and it is also the very heart of it. Constitution का soul भी है, heart भी है, and this right invested with the Supreme Court cannot be taken away unless Constitution itself is amended. So hence it was one of the safeguard that can be provided for the safety and the security of individuals, and it is the right, see, it is the right fundamental. ये ऐसा राइट है, राइट टू अप्रोच द कोर्ट अंडर फॉर द कॉन्स्टिट्यूशनल रेमेडी अंडर आर्टिकल 32 और 226. इट सेज इट इज अ राइट व्हिच इज फंडामेंटल टू ऑल द फंडामेंटल राइट्स गारंटेड अंडर द कॉन्स्टिट्यूशन. सो सुप्रीम कोर्ट itself has said the right to approach the Supreme Court under Article 32, जो राइट है अंडर आर्टिकल 32 is itself a fundamental right. ये अपने आप में ही fundamental right है, and that there is no doubt that if a citizen of India is deterred in any case, किसी भी केस में अगर उसको deter किया जाता है from approaching the court, this particular court, that is Supreme Court, in exercise of its right under Article 32 of the Constitution, it would amount to serious and direct interference in the administration of justice of the court. So I would like to conclude now by saying that in the state, by quoting the observation made by Justice Bhagwati in the case of state of Rajasthan versus Union of India, wherein he said that Supreme Court is the ultimate interpreter of the Constitution. It is for this court to uphold the constitutional values and enforce the constitutional limitations. That is the essence of rule of law. And if we see the journey of Supreme Court since its inceptions, we can safely conclude that Supreme Court has played a significant role in the promotion and the protection of fundamental rights of its citizens, and has given its judgment upholding constitutional value and fundamental principles. Whenever required, it has laid down the guidelines to be followed by the government or the authorities in the arena where there was no legislation. But fundamental rights of the citizen is violated, no legislation, then Supreme Court has intervened and had laid down the guidelines. They are said to be, they are presumed to be, they are said to by the court to be ad hoc guidelines only. That is, they are not a permanent, they are not legislating, they are for the time being only till the legislature makes a law on that. Again, it would not be wrong to say that whole of the environmental jurisprudence has been the contribution of the judiciary. Again, its role in the humanization of criminal justice system has led to the transformation in the attitude of those who are the part of criminal justice system. Right? And last but not the least, I would say that the Constitution has provided us with the fundamental rights. To every right, there is always a corresponding duty. So I will end up here by reminding the citizens that though you have a fundamental rights, but they should always abide by fundamental duties also, which is imposed upon them by the Constitution. Thank you very much.
Thank you so much, ma'am. Your knowledge speaks for itself. And this was indeed an inspiring and thought-provoking session, ma'am. Thank you once again. Now the arena is open for the question answer rounds. So we'll wait for a second, ma'am. We are just getting in the questions and then I'm going to ask you, ma'am.
Okay.
Ma'am, there are questions, a lot of questions coming in from the faculty as well as the students. So
Yes,
I would love to take the first question that is from the student itself. And it says that we often hear the term Bill of Rights. What is this Bill of Rights?
Okay. So, so far as Bill of Rights are concerned, you see in every democratic country, we do have rights which are given by the Constitution to its citizens. And not only they are given, they are even protected by the Constitution, that in case they are violated, they will be protected also. So all these rights are listed. उसको एक लिस्ट में लिख लिया जाता है. It's a form of list. जिसको हम कहते हैं कि दिस जैसे हमारे कॉन्स्टिट्यूशन ने फंडामेंटल राइट्स दिए हैं, तो वो जो लिस्ट तैयार होगी उनकी, तो दैट इज प्रिसाइजली रेफर टू एज अ बिल ऑफ राइट्स. बिकॉज हमारी हिस्टोरिकल, अगर आप लीगल बैकग्राउंड देखें या हिस्टोरिकली इफ यू सी the making of the constitution of number of countries, वहाँ bill of right का mentioning होती है. So bill of right is nothing but it is just a list of rights which the Constitution gives to its citizens, and they are that not only it gives its rights, it also ensures that they are not being violated by any other individual or even by the government during the course of its working. So this is precisely what is Bill of Rights.
Thank you so much, ma'am. Ma'am, the next question is from the faculty member, and it says that when we talk of freedom is given by our Constitution, don't you think that it is also include a freedom of press as well?
Yes. Freedom of press, yes. So far as freedom of press is concerned, I would say that Article 19, Clause 1 and Subclause A of Constitution of India gives a freedom of speech and expression. एक जो speech and expression है, उसमें even Supreme Court has interpreted that it includes a freedom of press. For instance, in number of cases like Express Newspaper versus Union of India, or there are so many cases जहाँ पर it has been upheld by the Supreme Court that freedom of speech and expression includes, क्योंकि वहाँ speech और expression को freedom दिया गया है, तो freedom of press is also included in that.
All right. Thank you so much, ma'am. Ma'am, there's another question that has popped up. It says that we hear a lot about judicial activism. Don't you think that there is no such concept in our Constitution, and we can say it amounts to amendment of Constitution?
No. Judicial activism and amendments, they are two different terminology, though judicial activism as such has not been as a word as it is not used in the Constitution as such. But जब ये public interest litigation का concept आया, the Supreme Court has started giving directions to the executive. It was at that very point of time felt that the legislature, it was not doing its job, or the executive head, they are lethargic. So Supreme Court thought it proper कि in its endeavor to protect the fundamental rights of the citizen, it thought it proper that any aggrieved party, whosoever comes or approach the court, it needs a redressal. चाहे वो एग्जेक्टिव स्लिपिंग ऑफ एग्जेक्टिव है या लेजिस्लेचर की लिथार्जी है, तो देन द सुप्रीम कोर्ट came forward to जैसे issue guidelines also, or to giving direction to the executive to work. So it is this is what was termed as or coined as a judicial activism कि judiciary activism की तरफ चल रही है. बट जो अमेंडमेंट है जो अमेंडमेंट है उसकी पावर जो है 368 के अंडर स्पेशल पावर हैज बीन गिवन, और उसकी पूरी लिमिटेशंस भी है पार्लियामेंट के ऊपर. तो जुडिशरी जो लेजिस्लेट कर रही है वो, या जुडिशरी जो एक्टिविज्म के उसमें जा रही है, वो अमेंडमेंट नहीं है. अमेंडमेंट पार्लियामेंट ही कर सकती है. यस, देयर इज अ पावर ऑफ जुडिशियल रिव्यू कि वो अमेंडमेंट जो है, जो मैंने 368 के अंडर पहले भी बोला था कि वो फंडामेंटल राइट्स के अंडर जो है, या अगर कहीं पे भी बेसिक स्ट्रक्चर की अगर वायलेशन है तो जुडिशियल रिव्यू के अंडर द कोर्ट कैन इंटरवेन एंड कैन स्टॉप इट.
All right. Thank you, ma'am. Ma'am, your lecture has been so inspiring that we are getting a lot of questions. But because we don't have time, so ma'am, I'll take a last question. Right?
Yes.
So ma'am, the question is, what is judicial legislation? The question is, what is judicial? Yeah, ma'am, I'll repeat it. Ma'am, the question is, what is judicial legislation? Because we understand that legislation is the forte of legislature.
Yes, like I have referred to Vishakha's case, and I have also made mention of D.K. Basu's case and Jogintar Kumar's case. In all those cases, I do say that judiciary has legislated. So it is an ad hoc arrangement which the judiciary make so that again in its endeavor to provide whatever is due to the citizens so that their rights are not violated. Suppose there is an arena where there is no law in existence, but there is a violation of fundamental rights of its citizens. So in all these cases, judiciary cannot say that we cannot provide you a remedy because there is no law at that very point of time. So as an interpreter of the constitution, as a guarantor, as a watchdog of the fundamental rights of the citizen, the Supreme Court, it just laid down the guidelines to which we precisely call it as a judicial legislation, and it is just an ad hoc legislation, and it remains in the force, and Supreme Court is very, very conscious, and it always says that it will remain in force only for the time when till the legislature legislated. When the parliament legislated on it, then the judicial legislation will only be in the papers only.
Right. Thank you so much, ma'am. Thank you for answering all our questions.
Thank you for providing me an opportunity to interact with your students. I'm really glad. And I'm really thankful to the team of, I'm really thankful to this principal sir, Dr. Seema and her team for really organizing, and congratulate you for organizing this webinar today.
Thank you so much. We are grateful. Ma'am, may I now request Mrs. Seema Suri, Head of the Department of Political Science, GGDST College, Chandigarh, to kindly propose the vote of thanks.
On behalf of GGDST College and Political Science Department, I extend my deep gratitude to the Chief Guest and Resource Person of today, Professor Dr. Vandana Arora, for sparing their valuable time and giving us the opportunity to know how Supreme Court has widened the scope of our fundamental rights, especially the right to life and right to constitutional remedies under Article 32 of the Indian Constitution. We are grateful to the college management and our worthy principals, sir, for their enthusiastic support. I express my gratitude to my fellow colleagues, especially faculty of my own department, Political Science. My special thanks to the technical support team, especially Mr. Keshu, for providing us technical assistance. My sincere thanks to our students, without whom this event could not be possible. Thank you all. Have a very happy and nice day. Thank you very much.
Thank you, ma'am. Thank you so much.